Welcome back to the business law course. This is the fourth section for the topic labor law. This is your lecturer, Sujanardan Nandi speaking. At the previous part, we have identified several classifications of the industrial relation dispute, namely the right dispute, the interest dispute, the termination of contract dispute, as well as the labor union versus labor union dispute. So those kind of dispute could be happen because there are some clash between the the employee and the employer, just like in the right, in the interest, and also in termination of contract dispute, or sometimes it's between labor union versus labor union in the same company, and those things could be happen in case of the employee versus the employer because the employee or the employer, one of the parties, is not fulfilling their obligation in the agreement, and in labor union versus labor union because they cannot find the common consensus about who is authorized to represent all the employees to negotiate with the employer. So what if those kind of things happen? What if your company doesn't pay your wage? The company is making regulations that bring disadvantage to you. So now what can you do? So now we are going to discuss here about the dispute settlement in industrial relations uh, dispute. Generally, the dispute settlement in labor law, some of the procedures are equal or the same with most uh, legal disputes outside the labor law dispute, but labor law has some um, unique settlement that distinguishes them with the other area of law. There are at least uh, three dispute settlement procedure. The first one is bipartite or bipartite in Indonesia. So bipartite is the main procedure that you have to follow when you got some dispute, whether you are the employee or the employer or the labor union. So bipartite is talking about direct communication, direct discussion. For example, you as the employee, your employer doesn't pay your wages after 2 months or 3 months, and you're asking them to pay it to you, but they don't want to pay it. So you must follow the bipartite procedure by asking them and make the confirmation to them directly, asking for a formal meeting, send them a formal letter, and then you can discuss it in a formal occasion and make the date or the conclusion of the meeting writtenly. So the written report could be the evidence if you want to bring it to the court one day, or maybe you want to follow the other procedures. So the point is bipartite is a dispute settlement made by the both parties directly by a negotiation, by a direct communication. So you can come to your boss, tell them what you want in a formal occasion, make the notes about it, both parties sign it, yeah? And then if the bipartite is giving a good solution for you, so after you negotiate with the company directly, the company and you get a common settlement, so the problem will be solved. Let's say that actually the company should pay you 200 million for the termination of the contract, but they only want to pay you 100, so you can negotiate with them. Maybe both of you will agree with 150 or something like that. So you can settle. But if they offer you 150, you still want 200, then bipartite fell. And if bipartite is fail, the other solution is tripartite. That's number two. Just like the name, it's called tripartite because it's involved three parties. You, I mean the employee, the employer, and also sometimes we involve a mediator. So this mediator could be a certain organization, a certain party, and usually, yeah, it's Dinas Tenaga Kerja, for example, the labor bureau, state labor bureau. So you can ask them to be involved there. After the bipartite is failed, maybe you can send some letter to the bureau, to the government, tell them your problems, and maybe you're asking also for a meeting, three parties meeting, you employer and the government. And then when it is conducted, it is one of the form of the three-party procedure, and maybe the government, after hearing the both parties' opinion, point of view, they could give some suggestion. So if you want to follow the suggestion, you make the deed of the settlement, and the problem finish. But if you don't want to follow the suggestion from the government, it's okay, because the position from the government um is not as the party that take the decisions of the court of the case. So they could give you some suggestion. If you want to take it, you make peace. But if you don't want to take it, you can continue the problems. So if the bipartite and tripartite is failed, then you can go to the court. Industrial Court. Indonesia, PHI, Pengadilan Hubungan Industrial. Where is it? In every capital city of the province. So if your company is in Cikarang, for example, and you want to settle your case in industrial court, so you go to Bandung. So every cases in Cikarang is go to the industrial court in Bandung. So using this procedure, you give the problem to the court, and the court will settle it. And from the previous discussion in this section, also I told you that you can communicate with your boss, which is also a classification of a negotiation. So you can settle with negotiation, yeah. And by involving the other party, like in tripartite, sometimes it's mediation or reconciliation. Yeah. This is only the further explanation about the bipartite and tripartite. This is bipartite, tripartite. What's the difference between mediation and reconciliation? It's only about the practical implementation. Yeah? In mediation, this is the employee, this is the employer. So this is the mediator. So it's called mediation. So here, the three parties meeting together, discuss together, so it's called mediation. But in reconciliation, based on some theory, because Indonesian law doesn't quite give a clear distinction between mediation and reconciliation, so we refer to some expert opinion. When we talk about the reconciliation, it's like the reconciliator firstly go to the first party, asking for what their interest, and then the reconciliator, after make a first meeting with A or the employee, the other day he visited the employer or B, asking for what their interest, and then this reconciliator could find the common interest of them, and then he will come to the employee again, and then come to the employer again, and maybe he could give some suggestions. So if the employee agree with the suggestions, he will discuss it again also with the employer. Do you agree or not agree? If employer also agree, then they get an agreement about the settlement, but without seeing each other directly. So actually, it's only about the terms, because in practical sometimes it mix. Sometimes you see together each other, the three party, but yeah, sometimes at the next meeting only two and two, just like a conciliation. So it's more practical things. Yeah. The other solution is arbitrage. Or arbitrage. So arbitrage is Another solution, one of the alternative dispute resolution using the institution called arbitrage. In arbitrage, um, we let our case settled by the arbiter. In the court, we have judges. In the arbitrage, we have arbiter. Judges are a career person, so they are start from the beginning is a judges. But arbiter is a professional. What does it mean professional? He is experienced in the sector of the business they are settling and also has a high education level. In the other side, judges sometimes is not quite experienced in the case he is settling because he is the law enforcer. But arbiter, maybe if this is the case of labor, maybe the arbiter is experienced as the HR of a company for 20 years and also has a doctoral degree. So the arbitrage institution appoint this guy as the arbiter, or maybe if it is the insurance case and then the case goes to the arbitrage, then the arbitrator will appoint a people who is experienced in doing the business of insurance and also have high education background. While in the court, the judges maybe has no experience in working in insurance, in working in banking. So he is only a judge, a career judge. So it is an option for you. If you want to go to the court, so the case will be settled by the judges. The price is more cheap, it's cheaper. But of course, the judge maybe is not quite experienced enough with the topic or the problems. If you go to the arbiter, you can think that the arbiter is no better about the case than the judges in the court. But of course, it's more expensive. Different with mediation, if you bring the case to the arbitrage, the decision of arbiter is binding. It's just like in the court. In mediation, if the mediator gives you suggestion, you disagree, it's okay. But if you bring it to the arbitrage, what the arbiter decide is a decision you have to follow, just like in the court. Because after you settle the case in the arbitrage, the decision in the arbitrage cannot be brought to the court again. As well as if the case is settled in the court, you cannot bring it to the arbitrage again. So how do I know whether a case will be settled in arbitrage or in the court? So the arbitrage procedure can be agreed in the beginning. In the beginning means in the contract. So if in the contract there is a clause say if any problems happen occurred by disagreement or the conduction of disagreement, both parties agree to settle it in the arbitrage, then you have to bring the case in the arbitrage. So you cannot go to the court anymore. So after the biparty, the triparty, the mediation fail, you have to settle it to the arbitrage. So the arbiter will be your judge. Let's say that in analogy, it's your judge. But it also can be agreed after the case happened. Let's say that the case happened, your company doesn't pay the money, so you want to fight for your right, and then you and your company agree, okay, let's finish it in arbitrage. Or maybe out of the labor law topic, for example, company to company have a problem in business, they agree. So there is a dispute here already, there is a dispute. They agree to settle it to arbitrage. So the consensus about settling the case in arbitrage can be made before the contract or after the contract, which is usually after the dispute is happened. But the both parties must agree to bring it to the arbitrage. If only one party want to bring it to the arbitrage, but the other doesn't want to, so you cannot bring it to the arbitrage. The only solution after the bipartite and tripartite fail, you can only go to the industrial court. So this is a dispute settlement system in labor law, especially in industrial relation. This is what you can follow one day if you got problems, whether you are the company, the employer, or maybe you are the employee. you have to follow it step by step. You cannot just go directly to the court. You have to settle it face to face first, yeah, by two sides, bipartite, and if no solution after the bipartite, you can asking for the third party to be involved, and they can give you suggestion based on their experience, based on their position as the government institution, for example. You can follow or you cannot follow. It's okay. If you like the solution and your opponents like the solution, then you make the deed of the settlement, perjanjian perdamaian. Then the problem finished. But if you agree, your opponent doesn't agree, you don't have to follow the suggestion because it's only a suggestion. Then, because we call it non-litigation, yeah, non-litigation means out of the court procedure. If the non-litigation already finished, no solution, you still want to fight, the opponent still stand on their opinion, on their standing position. So now you can asking the case to be settled by the authorized, whether the arbiter, whether the judges. Why I call it authorized, because the decision here in arbitras, the arbiter and also the court is binding. So you have to follow it. What they say, you have to follow it because it is binding, and you cannot bring it to the other side again if it's been settled by the arbiter. You lose, for example, you cannot say I want to bring it to the court. Maybe the court will make me win. No way. The court will reject the case as long as your opponent can prove to the court that there has been the decisions from the arbitrage. And also, on the other side, if you already finished it in the court, and then you lose, you cannot say I will try to bring it to the arbitrage because your opponent has an evidence, the decisions from the court, and they can show it to the arbitrage, then the arbitrage will reject the case. Because if the case already settled in arbitrage, you cannot bring it to the court. And also, if you finish the case in the court, you cannot finish it again after the court settle it in the arbitrage. So again, I ask you to read the books, to read the regulations, to understand about this topic better. So I think this is the closing of the labor law topic. I hope you understand the materials and keep on studying, keep doing your best, stay healthy, stay safe. Thank you. God bless you all.